what the International Registry is and why it matters. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with the first and most important point about the International Registry of Mobile Assets as it applies to aircraft. This is not merely an electronic filing system. It is a priority system built to follow high-value aircraft assets across borders. At the treaty level, the starting point is the Cape Town Convention and the Aircraft Protocol. In the United States, the implementing framework appears in the Cape Town Treaty Implementation Act. 49 U.S.C. Section 44113 and FAA regulations include 14 CFR Part 49. The FAA explains the central idea directly. The International Registry is an additional place for the filing of interests, including prospective interests in certain airframes, helicopters, and aircraft engines. That word additional, with emphasis, matters. The International Registry does not simply replace domestic title and recordation practice. In the United States, you still care deeply about the FAA registry. But for eligible aircraft objects, the International Registry is where the treaty priority is won or lost. The Aircraft Protocol defines which aircraft objects qualify. Broadly speaking, the system applies to airframes large enough to carry at least 8 persons, including crew, or goods in excess of 2,750 kilograms, helicopters large enough to carry at least 5 persons, including crew, or goods in excess of 450 kilograms, and engines meeting the treaty threshold for turbine and piston engines. That threshold is 550 rated takeoff shaft horsepower. For jet engines, it's at least 1,750 pounds of thrust. That means many business aircraft transactions are inside or subject to the International Registry. A large cabin Gulfstream, Bombardier, Dassault, Embraer transaction may well be a Cape Town transaction. So may the financing of a qualified turbine engine, even apart from the airframe. The convention also tells us what kind of interests matter. Under Article 2, an international interest can arise from a security agreement, a title reservation agreement, or a leasing agreement. Under the Aircraft Protocol, contracts of sale and prospective sales can also be registered. This is one of the reasons the treaty has become so important in private aviation closings. It addresses not only lender security, but also title protection, as well as sale priority. Now, here is where owners and even some advisors make costly mistakes. They assume registration creates the right. It doesn't. It does not create that right. The International Registry itself warns that registrations merely provide notice, and that the underlying facts determine whether the interest falls within the scope of the convention and protocol. In plain English, a bad transaction does not become a good transaction because someone clicked register. That is why the formal requirements still matter. Article 7 requires a writing, power to dispose of the object, and a description sufficient to identify the aircraft object. The Aircraft Protocol says manufacturer's name, model designation, and serial number are necessary and sufficient to identify the object. In practice, that means serial number discipline is not clerical housekeeping. It is legal infrastructure. A real-world perspective helps here. Before Cape Town, aircraft creditors often relied on domestic recording regimes and general commercial law concepts to protect moving assets. Cases such as Enri Western Pacific Airlines show the financing world that disputes over perfection and competing rights in aircraft equipment could become expensive, technical, and insolvency driven very quickly. Cape Town was designed to reduce exactly that kind of uncertainty for mobile aviation assets. And here's a point to remember: the International Registry is not paperwork, it is a priority architecture. For private aircraft owners, that means the registry should be viewed as part of the acquisition strategy from the beginning, not as a closing room afterthought. Council must decide whether the transaction creates an international interest, whether a prospective interest should be filed before funding, whether a contract of sale should be registered, whether an engine filing is also required, and whether the domestic recordation package is aligned with the treaty registration plan. In short, the International Registry matters because aircraft move, capital moves, and disputes cross borders. Cape Town gives the market a common priority language, but it works only when the transaction documents, the serial numbers, the filing strategy, and the closing execution are all lined up. Here's the takeaway. Remember this: in aircraft finance and ownership, the International Registry does not just record the deal, it helps determine whose deal survives. Priority, sales, and closing mechanics. Now let's turn to the second major issue: priority sales and closing mechanics. The convention's core priority rule is in Article 29. A registered interest has priority over any other interest subsequently registered and over an unregistered interest. It does so even if the first filer had actual knowledge of the other interest. This is the treaty's great commercial simplification. For eligible aircraft objects, priority is built around registration timing, not around sympathy, not around assumptions, not around who complains the loudest after closing. For buyers, the aircraft protocol adds another critical rule. Under Article 24, a buyer under a registered sale has priority over subsequent registered interests and from unregistered interests, even if the buyer had actual knowledge of the unregistered interest. That is why sale registration can be more than a nice extra. In the right transaction, it provides a measure of title protection. There is also an engine-specific point that deserves emphasis. The aircraft protocol states that ownership or another right or interest in an aircraft engine is not affected by its installation or removal from the aircraft. That matters enormously in business aviation, where engines can be swapped, financed separately, leased separately, or become the subject of separate disputes. If counsel ignores the engine analysis, counsel may be protecting only half of the asset picture. In the United States, there is an additional procedural layer. The FAA Civil Aviation Registry is the United States entry point for eligible U.S. civil aircraft. Aircraft assigned a U.S. registration number and qualifying engines. Under 14 CFR Section 49.63, a party seeking a unique authorization code must file AC Form 8050-135 and, for a U.S. civil aircraft or engine, file the related transaction documents with the FAA Aircraft Registry. The FAA reviews the form for completeness and returns a unique authorization code for use at the International Registry. The FAA expressly says that acceptance of the form does not mean the agency agrees with the filer's representations. The procedural details matter in practice. A lawyer can have a flawless deal document and lose priority if the registration steps are late, incomplete, or missequenced. The closing checklist must therefore identify the aircraft object, confirm eligibility, obtain the entry port authorization when required, complete the electronic registration correctly, secure the required consents, and confirm that the registration actually appears in the International Registry in the correct order. Another practical lesson comes from the Blue Sky One and Mahan Air litigation in England, which is often discussed in aviation finance circles because it exposed how aircraft title disputes can be multinational, document intensive, and brutally expensive when sale and financing structures unravel. Whatever one thinks of the specific holdings, the commercial lesson is pretty clear. Aircraft title and property disputes do not stay tidy once the asset, the parties, and the jurisdiction begins to move in different directions. That is one reason prospective registrations can be so valuable. The FAA specifically provides a process for prospective interests affecting eligible U.S. aircraft and engines. And a financed acquisition, filing a prospective international interest before the final funding event, can preserve the position while the parties complete the closing mechanics. In a world where wires can be delayed and signatures can arrive out of sequence, it's just more than administrative convenience. It's risk management. Another point is often missed by owner clients. Registration strategy is not only about lenders, it's about purchasers, agreements, trusts, agency structures, and representative capacities. The aircraft protocol allows persons acting as an agent or agency, trust, or other representative capacity to enter into registered interests in aircraft objects. So where the aircraft are held in owner trusts or special purpose entities, the registration analysis must match the actual transaction architecture. Here is something to remember. On the International Registry, priority belongs to the disciplined. The closing discipline, therefore, should be uncompromising. Match the serial number on the purchase agreement, bill of sale, security agreement, lease, FAA entry point filing, and International Registry registration. Confirm who must consent electronically. Confirm whether the transaction is a sale, a lease, a security interest, or more than one of those. Confirm whether separate engine registrations are needed, and confirm the discharge path for any prior registrations before money is released. The bottom line is simple. The International Registry rewards the prepared and punishes casual closing practices. In private aviation, where aircraft regularly cross state and national borders and where ownership structures can be layered, that priority discipline is not optional. Remedies, IDERA, and default planning. Finally, let's discuss the issues clients feel most sharply when a deal goes bad. Remedies, IDERA, and default planning. The Cape Town system can be powerful, not because it produces elegant filings, but because those filings are tied to remedies. The Aircraft's Protocol Article 13 addresses the irrevocable deregistration and export request authorization, or IDERA, where the debtor issues an IDERA in the required form, and it is recorded with the registry authority, and the authorized party becomes the sole person entitled to exercise the specific deregistration and export remedies, subject to applicable aviation safety laws and regulations. In the United States, Those treaty concepts are carried into FAA practice. The FAA explains the Cape Town framework establishes the right for owners of eligible aircraft to grant an IDERA to a secured party. Under 14 CFR Section 47.47, if an aircraft is subject to the Cape Town Treaty and an IDERA is filed, the FAA will honor a cancellation for export request only if the authorized party makes the request and certifies that all registered interests ranking ahead of it have been discharged or have consented. This is a crucial practical point. An IDERA is not a magic wand. It is a priority sensitive remedy. The requesting party must still deal with senior registered interests. So the creditor who assumes the filing of an IDERA alone guarantees a clean export is misunderstanding the structure. The treaty helps the secured party, but it does not erase the ranking order the registry itself created. The protocol also addresses insolvency. Article 11 provides insolvency remedies where the relevant contracting state has made the proper declaration, including Alternative A, which requires the insolvency administrator or debtor to give possession of the aircraft object to the creditor no later than the end of the waiting period unless defaults are cured and future obligations are agreed to be performed. For lenders and lessors, that is one of the most commercially important features of the Cape Town system. A modern example of why timing and aircraft lease remedies matter, Avianca Holdings SA, decided by the Second Circuit on February 3rd, 2025. That case was not a pure international registry priority dispute, but it shows how quickly aircraft financing rights can be litigated when a debtor enters insolvency. The court held that payment obligations under aircraft leases arose when they came due, not when leases were originally executed. The lesson for owners, lessors, and creditors is that in an aircraft insolvency, timing, documentation, and remedy structure are not academic. They will determine later leverage. There is also a practical export lesson hidden inside the FAA process. When an IDERA authorized party seeks cancellation for export, the FAA requires an international registry search certificate and proof that higher priority registered interests have been discharged or have consented. In other words, when default arrives, the search results become part of the remedy file. And that is why it's recommended that clients' search should not be treated as a one-time pre-closing exercise. It is part of the life cycle of the asset. For private aircraft planning, from a private aircraft planning standpoint, the right approach is to build the default file before any default occurs. And that means confirming treaty eligibility, obtaining the correct entry point authorization, registering the correct interests, recording sale registrations when appropriate, filing and recording any IDERA needed for the filing structure, mapping discharge authority, and preserving a complete copy of the search certificates and consent chain. There's another issue that deserves emphasis for owner clients. The International Registry protects priority, but it does not resolve every operational or local law issue. Aviation safety rules still matter, local court procedures still matter, export and customs issues still matter, and in some jurisdictions, the value of Cape Town remedies depend heavily on the declaration that state has made under the convention and protocol. So the right question is not simply, did we register? The right question is, did we register in a structure that will work under pressure in the relevant jurisdiction after default? I'd like you to take this away and remember this. The best time to plan for your aircraft remedy is before you need your aircraft remedy. When registration strategy is done well, it gives owners, lenders, and lessors a language of priority and a pathway to enforcement that can be understood across borders. But when it's done poorly, the parties discover too late that they have documents without leverage, filings without coordination, or remedies blocked by a superior interest that should have been addressed before closing. In short, the International Registry is where transaction planning meets enforcement reality. It's not glamorous and arguably not optional. And in a distressed aircraft transaction is often one of the first places where this outcome begins to tilt. I'd like you to take this away. In aircraft ownership and finance, the International Registry is not just about filing first. It's about being able to act first when the deal breaks down. Thank you again for your interest in this topic. This information is provided for informational purposes only. It should not be construed as legal advice. Questions? They're always welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to hearing from you and helping you navigate your aviation-related legal needs.